Kangethe, an advocate working with Sheria Mtaani na Shadrack Wambui as a litigation lawyer in that organization. So Sheria Mtaani, upon being instructed by members of society, petitioned the High Court sitting at Nairobi. And this morning, the High Court was pleased to grant orders in the form of conservatory orders, barring the NTSA from implementing the system, rolling it out, or in any manner imposing any fines whatsoever on any Kenyan with regards to the cameras and the systems that they had put up on highways. Reason being that this system was rolled out without consulting the law insofar as the rules that govern automated decision makers are concerned as under the Data Protection Act. Secondly, the NTSA has not made us aware where the fines are being channeled to, because we have the NTSA fund and we similarly have the judiciary fund where ordinarily fines that arise from criminal processes are usually channeled. So we are not aware where the money is being taken. And similarly, it is an unlawful taking over of the jurisdiction of the ODPP insofar as the NTSA purports to institute criminal proceedings against motorists. For this reason, the judge was pleased to grant us orders barring this system from being rolled out and has directed service upon the respondents and ordered that we appear before him on the 9th day of April 2026, where we shall take directions as to how to quickly resolve the dispute and perhaps see the way forward.
Press. Sheria Mtaani na Shadrack Wambui is a non-governmental organization that promotes accountability, good public governance, and proper institutional governance. This is a non-governmental organization that purely has the interest of Kenyans at heart, and at this instance, the motorists at heart. Now, we lodged a three-pronged attack on the recently rolled out NTSA instant fine traffic systems, which saw the automation of instant fines. The first ambit, or the first umbrella in which we lodged this petition under, was Article 50 of the Constitution, which demands that every person has the right to a fair hearing and fair administrative action. Now, through the imposition of these fines, what we see is that motorists are being fined on the spot. And then thereafter, they come back and tell us that after you've been fined, you can be able to come and try, and you can come back and try to defend yourself. What this action does is reverse the purpose of administrative action. The Constitution says, first of all, you are heard, and then sanctions are imposed upon you, not the other way around. The second umbrella is Article 157 of the Constitution, which gives the DPP prosecutorial powers. Therefore, what happens in this instance, or rather what is currently ongoing with this instant traffic system, is that it is somehow and somewhat removing the constitutional mandate of the prosecution and giving it to itself, and therefore the prosecution, or rather the DPP, has had its mandate curtailed by this system. Thirdly and finally is Section 50 of the Traffic Act, which gives administrative schedule on how the fines of motorists who offend traffic rules ought to appear and be conducted before instant fines or other sanctions are imposed. First is that you are summoned within 14 days of the fine, or sorry, you are summoned within 14 days of the offense, or two, you are given a warning at the commission of such or rather any particular offense, or three, you are given an intention to prosecute. Therefore, this instant traffic fine management system comes and does away with that law. No explanation whatsoever has been offered by the relevant public authorities as to why we are violating and going against already what is in the statutory ambit of what Kenyans know. Therefore, we call upon every motorist, every Kenyan, that we are here to defend the rights of motorists. If any of you receives an instant fine, you have the moral and civil and even the legal obligation to refuse to pay that fine. Therefore, let nobody harass motorists, as this is a matter where conservatory orders have already been issued, and therefore no motorist should be instantly fined with what has been recently rolled out. Thank you.
Of Sheria Mtaani, Wakili Stanley Kinyanjui has explained the role of NGO called Sheria Mtaani na Shadrack Wamboi. Shadrack Wamboi, we are sorry, is not present because he's bereaved. He traveled to attend a burial. Of fundamental consideration is that yesterday Sheria Mtaani's portal received more than 600 requests for us to take up this matter. These are 600,000 Kenyans who petitioned to us to take up the matter on their behalf. Their cries are monumental. We agreed to take up this matter. Among the issues that we have put to the court and we are putting to the country is one, about speeding. Courts listen to an accused person. You take plea, you give circumstances that made you overspeed. I'll give 5 scenarios. Ambulances will not drive at the normal speed. They are going to be fined. We are now going to have ambulances going at a snail's speed, and very many Kenyans and the mothers who are going to give birth at Pumwani will die. The second issue is the circumstances, especially now when we have floods. People are driving alert that floods can come from behind. So if you see a flood, storm water coming, are you going to drive at a speed of 10 kilometers per hour? You will have to overspeed to save your life. Third, criminal arms. Criminals sometimes want to carjack motorists. People drive so fast to rush to police stations to save their life. And very many situations, and that's why the law allowed that after you have taken plea, you are given time to explain. In this instant situation, there is no plea taking. Number 2, under the laws of this republic, all prosecutorial processes are governed by the Criminal Procedure Code. The Criminal Procedure Code and the Constitution of Kenya mandates only the judiciary to impose fines. NTSA is an arm of the executive power of the state. The state cannot, through NTSA, impose fines. That is making the judiciary lose its mandate under the 2010 Constitution. 3, the mandate to prosecute anybody who has committed a traffic offense is a mandate of the Director of Public Prosecution under Article 157. The Director of Public Prosecution has been removed from these processes. And we are saying that cannot be the practice as we are saying. Third, under the law, fines are static. Once you have been fined 10,000 shillings, it does not attract interest. government has no business to get interest from its own citizens. You are fined 7,000 shillings, you are given 7 days to pay. Failure to that, then that fine continues to increase, to attract interest. Under which law? You are either fined 10,000 shillings or 200 shillings, and you pay that. So that is an illegality and a government that has turned to extort from its own citizens. Next, we are told if you fail to pay, you will never transact on NTSA portal. The offense was committed on Kangemi. That is the offense that the government has against you. If you want to sell your car, a different car, you are told you cannot transact on NTSA platform. Under which law? Under which law? Kenyans who have taken plea are not restricted to transact on any other platform of government. This is illegal, it is unconstitutional, it is exploitative of the citizens of this country. NTSA portal belongs to us. Article 1 of the Constitution says we, the people, are sovereign, not NTSA. Another issue is public participation. When were motorists ever asked whether they want this law to become law? Failure to comply with Article 10 of the Constitution that demands public participation is fatal. And the judge has agreed with us that that is fatal. Lastly, KCB, where Kenyans are being told to pay, which government account, which judiciary account is in KCB? We are very certain this is a personal account of somebody where fines are going to be put. The drama about e-citizen is still there. Kenyans have always asked, who is the owner of e-citizen? So the second question we are asking, this money that is supposed to be paid to a KCB account, who are the signatories? And what is the law dealing with that money? Based with those arguments, we presented a serious petition to the judge, and the judge has allowed immediately cessation, no more payment of fines through that portal. They have been given time to respond, and we expect them to tell us within a very short time why they have been illegally processing this. We have an issue, and we have an issue on one issue. The judiciary seems to be tilting to bed with the executive. When these policy documents were being announced, the Chief Justice was present. And the Chief Justice could have simply advised them that this is illegal. Kenyans cannot accept where the executive has taken over the role to fine people. Next time, we will be fined for being citizens. Next time, women will be fined for having long hair. There must be order. There must be a process. Parliament is still there. If they want to take this process, let them take to Parliament. Let citizens be involved in active public participation for the law to be there. So, on our position, we have made it illegal. For now, any fine imposed is an illegal fine. Sheria Mtaani with Shadrack Wamboi complain, and we shall deal with that. Because this affects border friends of ours, because this thing affects people who might not be able to follow in English, allow me to put it in Kiswahili that asasi ya kusajili magari NTSA walitoa ilani ya kwamba wataanza kupiga fine yeyote yule atakayekiuka sheria za barabarani ama za traffic kwa njia za mtandao. Juzi na jana Wakenya wamepigwa fine kila mmoja shilingi 10,000. Kosa la traffic linategemea upesi ama umeenda kiasi gani. Sisi tumeelekea mahakamani baada ya kupata Wakenya zaidi ya 600,000 wakiambia sheria mtaani na Shadrack Wambui tuwatetee. Tumeweza kueleza shida za Wakenya kwamba hakuja kuwa na mjadala na raia, public participation. Pili, ile account pesa Wakenya wanaambiwa waweke hatujui ni ya nani. Tatu, ofisi ya mkuu wa mashtaka ODPP imeondolewa. 4, judiciary mahakama imeondolewa. Na mwisho, zile fine hazijapeana ule mtu haki ya kujitetea. Jaji wa mahakama kuu amesimamisha hiyo ambayo tumesema ni illegal. Kwa hivyo tunatangazia Wakenya kwamba mtu yeyote asilipe fine ambayo itatokea baada ya onyo hili. Tumeambiwa tuweze kuwapatia makaratasi na tumewapatia makaratasi. Wamepata yale makaratasi ya kotini, wamepata oda ya koti. Kwa hivyo Wakenya, kueni tayari, bado kuna vita vya kukomboa Wakenya kutoka minyororo ya kusalitiwa na serikali ambayo tulichagua. Sisi ndio wenye serikali, sisi ndio wenye NTSA, sisi ndio wenye mahakama, sisi ndio wenye ODPP kulingana na kipengele cha kwanza cha katiba ambacho kinasema sisi, we are the sovereign. Nguvu zetu tutazipata kama serikali ikijaribu kutugandamiza kupitia sheria mtaani. Na washukuru wa Kenya, sisi tuko tayari kuwahudumia. Hatulipishi pesa zozote wakati ambapo tunakuja kotini kutumia njia ya sheria mtaani na Shadrack Wambui. Hili ni jopo la kusaidia Wakenya ambao wamepata shida, yani sheria mtaani. Ule mtaa wako unaishi Kawangware, ule mtaa wako unaishi Dandora, ule mtaa wako unaishi Kisumu, ule mtaa wako popote ulipo, sheria mtaani itakuwa pale. Nimalizie pale unless kuna maswali kutoka wanahabari.
You mean NTSA has mounted a kangaroo court along the Kenyan roads to the exclusion of the DPP and the judiciary, and also no one is condemned and hurt. Why are they doing it?
Courts in this country are gazetted in the Kenya Gazette. Any court must be gazetted. Milimani, where we are, is gazetted by Kenya Gazette. Last week, the Chief Justice gazetted Small Claims Court. NTSA has not been gazetted as a court. If it wants, it applies. Similar provisions for establishment of a police station, the IG must gazette. Therefore, the courts at NTSA are kangaroo courts. They are unknown, they don't exist. 2, in kangaroo courts, the principles under Article 50 and Article 49 of the Constitution are not applicable. The separation of power between the legislature, the executive, and the judiciary is very well defined under the Constitution of Kenya. Therefore, what NTSA is doing is illegal, it is unconstitutional, it is an overreach over their powers, and that is why the court has agreed with us that they do not have the legal capacity to impose fines.